Hello guys, welcome to our channel. Today in this video, we will discuss can the SEC beat XRP? Did the judge declare a small victory in their favor? But before we start, make sure to give this video a big thumbs up, and if you are new to the channel, don't forget to subscribe before leaving. Also, hit that bell icon so that you can get notified whenever we will upload a new video. For now, let's get back to the video straight away. Ripple is currently in a legal battle with the Securities and Exchange Commission, fast arriving at summary judgment time. While many people believe the SEC is in the wrong, there's also a valid argument that both sides could win. John Deaton, a crypto lawyer representing more than 50,000 XRP holders in the case, has suggested possible scenarios where both sides win. The long-running SEC versus Ripple case took a new turn recently when a U.S. district judge denied a request by the Commission to dismiss Ripple's fair notice defense. The motion filed by the SEC sought to restrain Ripple's argument that the watchdog failed to warn it of wrongdoing adequately. The judge's ruling was seen as a victory for Ripple, as the SEC would now have a much higher burden of proof. However, in a Twitter thread, Deaton said that Ripple, a fintech company that provides banking and payment solutions to financial institutions worldwide, could still lose the case. Deaton's argument consists in the fact that both sides will have to agree to a list of agreed-upon indisputable facts, and that the acceptance of this factual scenario can then remove the lawsuit from being decided by a jury. However, the lawyer notes that if there are disagreements over this legal aspect of the case, which have been active since December 2020, its fate will be in the jury's hands. To further illustrate his point, Deaton gives the following example. If the parties in a car accident case don't agree on the traffic light's color, the jury decides. But if both parties agree the light was red, there's no need for a jury to decide. Hence, Ripple and the SEC could agree to all relevant facts. The XRP lawyer also said that the two sides would be meeting this week to see if they could agree on a summary judgment scheduling order. Ripple was pushing for initial briefs to take place in mid-May. Deaton, however, hinted that the initial brief and Daubert motions could start by early June. As the SEC and Ripple continue to battle it out in court, cryptocurrency investors wait to see how the case will play out. Both sides have valid arguments, and it's possible that both could come away victorious. However, as of now, and this is based on the case's latest developments, it seems that Ripple is in a better position to win the case. The SEC has yet to present a clear argument as to why XRP should be classified as a security, while Ripple has provided a number of compelling reasons why it should not. While the case's outcome is still up in the air, Ripple appears to have the edge. On May 3, 2022, the SEC announced that it is expanding its crypto assets and cyber unit by a factor of 2. At least 20 new investigators and litigators were announced as part of creating these new units. Securities law violations related to a variety of crypto market entities such as crypto asset offerings, exchanges, lending and staking products, and NFTs, as well as decentralized financial platforms, stablecoins, and other forms of decentralization will be the primary focus of these newly created SEC units, according to the agency's announcement. It is now becoming clear that the SEC is out of its depth, and they are finally showing its true colors. It's almost as if they're out to harm cryptographic projects somehow. Regardless of how you look, this latest development is extremely disappointing. Hester Peirce, an SEC commissioner, questioned the agency's role in the crypto market in response to this news. SEC is a regulator with an enforcement division and not an enforcement agency, she tweeted shortly after. So why are we the pioneers of crypto enforcement? Hester Peirce's tweet sums up everything wrong with the SEC's long-standing problem with the crypto market under the leadership of SEC Chief Gary Gensler. We're all aware of the importance of timely and effective regulation. Crypto markets have exploded recently, with retail investors bearing the brunt of abuses, as the director of the SEC Enforcement Division stated in his briefing. Our financial markets and participants are still at risk from cyber-related threats. When it comes to protecting investors and keeping markets fair and orderly, bolstered crypto assets and cyber units will be on the front lines. As promising as this may sound, the SEC's approach to regulation is flawed. Scam projects and shady actors in the industry should be the focus of their attention, not new coins in the crypto market. It ought to be their primary concern, not to mention that the SEC has not yet provided any guidelines on how it intends to oversee the crypto market. As a result, new crypto projects have no idea what they're doing right or wrong. Because the industry is so unregulated, project creators often find themselves in limbo where they don't know what's wrong or right. As a result, can we genuinely hold them responsible for any mishaps? No. And herein lies the irony. The SEC is doing far too little to combat this problem. They are hiring more people to attack different projects based on arbitrary criteria rather than providing clear guidelines for these good actors. To some extent, If the SEC is only targeting the bad actors, that could be considered a positive development by some. Because the SEC is only interested in going after projects that will let them the most money, they have recently increased the number of regulatory enforcement officers they have on staff. For the time being, all that can be hoped for is that Ripple prevails in this legal battle, as the SEC's power would be severely curtailed as a result. With the SEC's handling of this, good projects will be pushed out of the United States, which is a fascinating and eye-opening point of view. Regardless of how you look at it, this will have a negative impact on the crypto market in the United States in the future. Jeremy Hogan, a legal entity, also weighed in on the debate, tweeting, "I receive emails weekly from people who are scammed, etc., and many are horrific stories. Why isn't protecting fraud against retail first, second, and third on the SEC crypto agenda?" Jeremy Hogan, on the other hand, was amused by the situation. It wasn't long before he tweeted, "The SEC hires 20 more lawyers and staff to crack down on crypto abuse, but doesn't hire a single lawyer to draw out clear regulations about exactly what abuse is." It must be extremely difficult for a new lawyer to learn the ropes. The SEC has nearly doubled its crypto unit. The SEC has been investigating Ripple for some time now. There was a new SEC filing in the Ripple and SEC case, so we'll go over that first. RPI requested additional time to respond to SEC claims of attorney-client privilege over Ethereum, free pass emails sent by Bill Hinman to Ripple. If you recall, a nonprofit organization called Empower Oversight obtained a cache of Hinman's emails and released them to the public. There are obvious conflicts of interest in Hinman's position as SEC director, as evidenced by this email. Hinman's emails, according to Alderati, showed that the SEC had a control breakdown, as he put it perfectly. How did that come about? To me, that seems like a basic question the SEC should be asking. A controlled breakdown occurred, and why is the SEC not treating this controlled breakdown with seriousness? As a result of the recent hearing, Ripple now has additional time to respond to the SEC's request for attorney-client privilege status for these emails. This gives Ripple more time to fight this request. However, the SEC has requested a response to Ripple's claim that the emails are not protected by the attorney-client privilege and has requested that a response be filed. According to a tweet from Ashley Proper, the SEC has already predicted the problems Ripple will point out with their attorney-client privilege motion. Before submitting the motion, I should have considered these issues. Incompetent lawyering. Because the SEC claims to want to appeal Ripple's claim of attorney-client privilege on the Hinman's emails, Ashley Proper was implying that the SEC had not yet seen Ripple's appeal. Jeremy Hogan suggests that the SEC appears to be saying it doesn't matter what Ripple says, they will appeal this regardless. If this is the case, there is a high probability of a delay in judgment. This case is being used by the SEC as a weapon against Ripple rather than being fought on merits. Ripple attorney Jeremy Hogan appears to have hinted that the SEC is hiding a document in which they concluded that the cryptocurrency is not an investment vehicle, even though this hasn't been confirmed. However, as with everyone else, we should be patient and wait for the release of the complete email. So there you have it. Ripple appears to be on the verge of a major victory over the SEC, as the release of the email should increase the likelihood of Ripple winning the lawsuit. That's it for today, guys. We will see you next time. Until then.